Hello everybody. A series of sharp comments on the state of Indian judiciary by Vice President of India Jagdeep Dhankhar and the subsequent responses to him by senior advocate Kapil Sibal have ignited a debate on several issues. To talk about this, we have with us Mahesh Jethmalani, legal expert and senior advocate, Supreme Court. Thank you, Mr. Jethmalani, for joining us on NDTV. Also, thank you so much for waiting. Sir, my first question, how do you see the war of words between Jagdeep Dhankhar and Kapil Sibal? Because this has raised a lot of questions on separation of powers, judicial overreach, and also constitutional decorum. Help us understand this.
Well, I mean, I think it's misconceived because the attack on Vice President Dhankhar has been that he occupies only a ceremonial office and he's spoken out of turn. That's the kind of argument. But he's not said all this in discharge of his ceremonial duties. Had he made this statement in discharge of his ceremonial duties, then you could have said he had crossed the lines of propriety regarding the performance of his duties as vice president. But he has not done that. I mean, this is not in performance of either his duties as the chairman of the Rajya Sabha or as the vice president of India. He's done this in a speech which he has made to Rajya Sabha interns. That's all right. I mean, there's nothing wrong with that. And it's in response to a judgment which he felt. Don't forget, he as vice president, he also has an obligation to uphold the Constitution, right?
Right.
And if he feels that the judgment, which prescribes time limits for the president to decide on bills reserved for his assent by a governor. Right,
yes, but coming to that, sir, the vice president's strong remarks, of course, like you said, against the judiciary also comes in the heels of Supreme Court order in the Tamil Nadu case in which it ruled that the governor's R.N. Ravi's decision to withhold assent to 10 bills was illegal and arbitrary. Now, in that context, the analogy that he used of Article 142 being a nuclear missile against democratic forces, as a lawyer, would you see this as fair characterization?
Well, no, 142 is not a nuclear, is not a nuclear missile. But what he probably meant was that it can't be a fallback provision on every and any sort of order which the Supreme Court wants to follow. See, the substance of his criticism, to be fair to Vice President Dhankhar, the substance of his criticism was, right, that this matter involved a question of law regarding a constitutional interpretation of a constitutional provision, right? That, and as per Article 145.3, sub-Article 3 of the Constitution, explicitly requires the matter to be heard by 5 judges. It could not have been disposed of by 2 judges, right? Now, the matter came to the 2-judge bench of Justice Pardiwala and Justice Mahadevan by way of writ petition, right? Under Article 32, I presume, right? And once they found out that it involved a question of law regarding interpretation of a constitutional provision, they should have referred it to a Constitution bench,
right? Because
that's the mandate of Article 145.3. That's all he's saying. What he's saying is that when you have an express provision, right, regarding the number of judges required to deal with a particular type of situation, in this case, a constitutional provision, interpretation, right? Then you can't use 142. That's what he really meant. Because the whole court,
so there's no review of
142.
Yeah, there's no review of Article 142 that is needed, or as some people are suggesting.
He didn't say that at all. I mean, I think that's that's misrepresenting his argument, right? It's in the context of what he considered to be a flawed judgment of a 2-judge bench of the Supreme Court. That's
absolutely, Mr. Jethmalani. Also, coming to another point, would you say that the separation of powers, is it being blurred at some level now? And the other question is the political class also breaching this long-established unwritten rule, the red line vis-a-vis Indian judiciary? Do you see that in the context of everything that has happened in the last few days?
Well, I think in recent times you've had, and you see, as a government becomes more and more powerful in terms of its numbers, right? And in terms of the number of states it also starts controlling, as the NDA has started doing, right? There's a pushback. The opposition starts relying on the judiciary, right, to advance its agenda. And the judiciary sometimes gets into these cases, sometimes it does not.
Right.
There are a lot of political cases pending in the Supreme Court at the moment and in the past, right? it started with an activist Chief Justice like Justice Chandrachud. He took up all kinds of constitutional issues and, including some of his own personal, the ideological issues. So it happened, and it's a fact. So it's continued. Now, the fact of the matter is that while there was this overstepping or overreaching itself, judicial overreach by the judiciary, now the pendulum is beginning to swing the other way because I think it started really, the consciousness started with this Justice Yashwant Verma's thing. Yes. That listen, all is not right with the judiciary. And,
yes,
they're behaving like a opaque sort of brethren,
right,
covering up each other's tracks and so on and so forth, right? So I think it started with that, and then people started looking at them more closely, and they found that there is judicial overreach in terms of, also intruding onto the executive sphere. Now, this is a clear example. The question which came up before this two-judge bench was one of that governor of Tamil Nadu's conduct in respect of the 10 bills which he set aside or rejected or withheld his assent, right? I don't know the exact nuance of what he did. But it had nothing to do with the president, right? It is true that there was one bill which he sort of reserved for the presidential assent. He said that I want to refer this matter to the president. And, without the president having even done something, an order was passed that the scope of his power is to do this within 3 months.
Right.
Now, it was not necessary to decide that case. So in that sense, it was like an academic exercise. It's a very well-written judgment. What I've read about it, the two-judge bench, is a very profound judgment. But it was unnecessary for that decision, apart from what Dhankar ji also pointed out, that there was a issue regarding the number of judges who could decide that kind of a case.
Absolutely. One of my last questions to you, Mr. Jethmalani, coming back to the language, how do Mr. Dhankar's remarks compare to the expectations and responsibilities associated with the Vice President's role? You already said that it's largely ceremonial. And in the same context, should somebody as senior as Kapil Sibal also looked at having some sort of restraint before commenting on this?
Well, look, Kapil is not just a lawyer, but he's also a politician. So, he's going to politicize these issues when the thrust is against causes which he espouses. So that's par for the course. You've got to expect that from Mr. Kapil Sibal. Anybody who's a lawyer, politician will always, stop very strictly wearing his legal hat and traverse into the political arena. That's okay. That's expected. So he attacked Vice President Dhankhar, but I think the attack was largely unwarranted.
Okay. Last question, sir. Also because, Article 142, after what Mr. Dhankhar said, is also being seen as this political, or is this weapon by judiciary to attack democratic forces. Please help us understand how should we rightly interpret this in the context of democratic checks and balances? Is there actually room for its misuse, or is it essential to judicial independence?
Well, no, it's not essential for judicial independence, but it is essential for the more effective discharge of the Supreme Court's duties. Article 142 is a residual power, right, which the Supreme Court uses, right, to advance the cause of justice. So it's like when other provisions are silent, right, and there's a vacuum, and you're required to take a step to advance justice, for which there's no specific provision, then you take recourse to 142. But it's also equally, on the other hand, very clear that you can't use Article 142, right, as the foundation of your judgment when there are other provisions which run counter to what you want to use Article 142 for. For instance, when there's an Article 145, sub-Article 3 provision, then 142 can't be used to, be the foundation of your judgment.
Right. Thank you, Mr. Jethmalani. Always a pleasure talking to you, sir, and thank you for your time and for your insights. Thank you so much.
Thank you. Thank you, Masud.